Carl, and thank you everybody for being here. I have some opening remarks. They're certainly not remarks that you all need to agree with. I've tried to be a little bit provocative just to set a bit of the tone at the outset and to say where we were coming from in making this conference. Uh, so, uh, my name is Roger Green. I teach in the English department at Metropolitan State University of Denver, which is a sponsor for our conference. So I want to start by saying a special thank you to Metro State University's English department. I'm also the current editor of the New Polis, which I run with my colleague Carl Raschke, who you've just heard from, and a growing number of graduate student interns at the University of Denver. Uh, the New Polis is a labor of love born out of some discontent with a perceived lack of critical thinking. I think particularly in the discourse of political theology, which, while at times I find useful, at other times has merely provided a kind of feedback loop into Western epistemological traditions, while covertly and at times unintentionally perpetuating colonizing tendencies. So my personal interest in decolonizing developed from the studying of the global diaspora of ayahuasca use from South America and the ways rhetorical gestures towards indigeneity seemingly appeal to those who would critique Eurocentrism on the one hand, even while they play into and emerge from the grossest forms of extractive capitalism. Spiritual journeying for those privileged by possessive investments in Western liberalism as an economic impulse, always directed at the conversion of people into rights-bearing individuals, is an expression of that same extractive impulse that would convert land into property. Spiritual flourishing, as the liberal youth of the 1960s and the older psychedelic movement precedented, globalized as it spiritualized. Global consciousness, even when uttered with the well-intended environmentalist concerns, for example, has largely been expressed by elites of the capitalocene and impulses towards development and civilization, as those living in the global south are perhaps more acutely aware than those of us living in the north. Also, androcentric notions of the Anthropocene perpetuate a legacy of European Renaissance concern with the human or with man in the sense that has been critiqued by Michel Foucault and by Black feminism more robustly. Um, so, in this current moment that we're in, we hear a lot of language around neoliberalism, and neoliberal impulses have made a mockery of praxis driven impulses to not merely interpret the world, as Karl Marx once stated, but to change it. Um, Yet this broader impulse to change and to convert is strikingly laden with Euro-Christian impulses that express what my Washaje or Osage Nation colleague Tink Tinker identifies as a Euro-Christian worldview, which is not to be confused with ideology or culture or race or religion or belief. It's a worldview. Those are all abstractions produced by a cognitive empire and its desiring machines, to use Deleuze's term. It is not only a crisis of imagination, but a crisis of the imagination, as conceived through humanistic spiritual flourishing or homo faber, that would subject us to the nightmarishly infinite virtual space of liberalism, all the while calling us sovereign kings in our confined nutshells. Mysticism breeds a kind of quietism or conservatism. Neoliberalism makes all people into mystics in a seemingly inescapable order of things, a universal cosmos. The mystical personal is the political, and the political is a flattened Euro-Christian basileia or kingdom of Christ, a regime of interchangeable significations in a vertically ordered hierarchy. Neoliberalism is but the latest mind manifestation that presences a latent Euro-Christian worldview as an imminent condition for all life. Such a reduction is what I mean by empire in our conference title, an order of things. And by cognitive, I mean a way of knowing. As Boaventura de Sousa Santos whose recent book, The End of Cognitive Empire, resounds in our conference title, as De Sousa Santos writes, quote, "The core problem is that the epistemological premises of both Eurocentric critical thinking and Eurocentric conservative thinking have strong and fatal elective affinities that he calls epistemologies of the North. Among his many suggestions is that we need not another theory of revolution, but we need to revolutionize theory. Yet this effort has been undermined by a passive acceptance of neoliberalism and global capitalism as an inescapable status quo. Such an acceptance of the way things are signals for many, especially in American universities, the end of any need for critical thinking or critical theoretical thinking, because it accepts that there's nothing outside of the status quo, and that the status quo is merely a matter of the appropriate recognition of various individuals' and groups' rights. Yet the concept of right maintains a vertical cognitive metaphor present throughout Proto-Indo-European languages of an up-down hierarchy. Moreover, there is an assumed audience capable of doing the recognizing that has traditionally been abstracted as law or as nomos. The audience is not a Greek chorus collectively speaking the needs of a particular polis in the name of justice. The cognitive empire existing today is an extension of a Euro-Christian worldview that melded messianic impulses towards salvation with the soul with Roman conceptions of empire and converted land and people into resources and property. Here is not merely a convenient Marxian notion of ideological mystification or finger-pointing at organized religion as an opiate of the masses. No, the individuated Euro-Christian subject could, through its journey toward salvation, do God's work. And I'm not distinguishing here between a Weberian kind of Protestant ethic or of asceticism and a Catholic universalizing extraction of land, animals, people, and labor. They both share the same worldview. Boaventura de Sousa Santos sees in coming epistemologies of the South some alternatives. If you could mute yourself, please, or Carl, do you want to just mute people and I'll restart?
Voy a solicitar que me manden las opciones que tengan mis chicos para aprovechar el gran veo que estamos haciendo con ellos. Y
Please keep yourself muted if you can. Where was I here? So Boaventura de Sousa Santos sees in coming epistemologies of the South some alternatives. I'm open to such alternatives, and of course that is partly why we invite this conference. Simultaneously, I'm fortunate to be aware of American Indian perspectives closer to where I live, on lands traditionally inhabited by Cheyenne and Arapaho peoples, here in what we call Denver, Colorado, is the colonizer language for this place. Traditionally inhabited by Cheyenne and Arapaho peoples and shared with many others. And here I say shared in quotation marks because that already implies a gesture of distance between land and people that I think is kind of foreign to indigenous people's ways of being, a gesture of dominion that needs to be unthought. In saying that, I'm in no way signaling an ahistorical Euro-Christian notion of the commons, though I find that notion useful in other contexts. I'm rather drawing attention to the alternative ways of being, deeper than epistemologies, that share co-presences with my own, yet that have been actively erased throughout colonial history, and a disposition that wants to situate the violence of colonialism into a distant past. And where, I don't know if it's different where you are, but definitely where I am, people try to distance colonialism to the past. Here is not a matter of becoming culturally competent on my part, Roger Green, even less so the genocidal idea that we are all somehow becoming indigenous as a result of the threats of extractive capitalism and deterritorialization. Rather, I gesture towards those who may know ways that I do not. So it's important as I end my opening remarks here to at least acknowledge the presence of a recent global pandemic, if only because it has transnationally signaled a state of global crisis and exception. I do not believe that I personally occupy a vantage point to possess what's really going on, and frankly, I'm suspicious of those who do that. That said, I agree with Boaventura de Sousa Santos when he says, quote, under the logic of permanent crisis, people are led to live and act in crisis, but not to think critically. While not mentioned in the initial conference description, the fact that we're having a global conference via the internet this week speaks to present conditions that affect all human life on the planet and animal life as well. That crisis has surely created opportunities for those who would prey on other lives and extract whatever wealth they can gain. Where I live, the political air has significantly relaxed with the defeat of Donald Trump, who seemed to embody a constant crisis. Yet a return to order with the present regime, often coded as normal, remains entirely suspect to me. If normal means the persistent state of extractive policies and US hegemony, such a status quo needs to die in the same way that Russell Means said in 1980 that for America to live, Europe must die. There he lamented the dead, dry leaves of books and Eurocentric impulses towards writing. Our situation now is demanding something different. Without romanticizing new media or assuming that all people have access to it, we are here in an attempt to find new ways to relate to one another from various places and positions in the world where we've become more intimately aware of how interrelated we all are, even if that doesn't equate to us all being the same. With that said, I welcome you and thank you all for joining us in these efforts. Let the conference commence.
Okay, thank you, Roger. To get started, I'm going to make a few remarks, though I think Roger certainly provoked us here, and it's come to my attention over the past 6 months as we've really been developing this conference that it's easy to look at the topic as just another kind of academic issue or as a kind of public intellectual issue. The word decoloniality is out there. Cognitive empire isn't such a familiar term necessarily, but it is provocative in its own right. And again, as Roger mentioned, that's a word. So we have to ask what do we mean by decoloniality? And I think we'll find in the conference there's tension even among the so-called experts of those who are associated it. One of the tensions is that we find between those who are in a sense long inhabitants of this continent, from different backgrounds, different stocks, who are in a sense hybrid. In Spanish, mestizo. When we're talking about descendants of slaves, we're talking about Creoles, and so forth. The mixing of peoples, and so what does indigenous mean, et cetera, et cetera. Very often we use the word decoloniality in different kind of ways. I want to start off by mentioning the idea of decoloniality that comes from Walter Mignolo, who's probably most closely associated with the term, though it was Aníbal Quijano, who was a Peruvian critical theorist a number of decades ago, who actually coined the term when he talked about the colonial matrix of power. For Mignolo, decoloniality means essentially the rhetoric of modernity and anti-modernity. He says that basically coloniality and modernity are two sides of the same coin. And so when we're talking about modernity and we're talking about coloniality, we're looking at the same thing. We're looking at not only lived ways of being, forms of life, but we're also talking about epistemes, as Foucault puts it, structures of knowledge, or to use the terminology of a well-known contemporary political theorist, George Lakoff, we're talking about the ways in which we deeply frame things, deep frames. This deep framing has a lot to do with our kind of linguistic habits, just the way we talk about things. That's why when we get into the rhetoric of contemporary identity and what we can, the politics of representation and the politics of recognition, where in a sense we want to make invisible people now more visible, we have to be very careful about our language. I mean, that's what the issue is. And that's Mignolo's point. That language matters, and language not only structures, language frames, and language seeps into, to use a broad term, our unconscious. So we're looking at modernity. In a lot of ways, modernity is the problem. And it's not only Mignolo, other writers have pointed out how modernity and the Renaissance from the 16th century and the beginning of the age of discovery, had a lot to do with what we consider to be the actual historical, the horrid output, particularly with the elimination of indigenous peoples but also about the enslavement of people. I want to just finish up here by reading a quote from a thinker who is from the Caribbean. She's a Caribbean thinker. She's one of the more prominent 20th, 21st, early 21st century Black thinkers by the name of Sylvia Wynter. She writes in a very important essay on decoloniality of being. She says, the struggle of the new millennium will be one between the ongoing imperative of securing the well-being of the present ethnic bourgeoisie, their conception of the human, which over-represents itself as if it were the human itself, and that this well-being and therefore the full cognitive and behavioral of the human species themselves, because of all this, has to be taken into account. So we're looking at being, knowledge, and ways of being, praxis, to use the terminology of Catherine Walsh, who will be talking later today. Catherine Walsh and Walter Mignolo have written a book that lays out in a very interesting way, the issues that we really want to address in the conference, not just talking about the problems of the Western episteme or how we think. It's also about what we do, how we act upon our knowledge and how we structure the world politically, socially, economically, and of course, even more importantly for us, what we take to be for granted, the very nature of the production of knowledge, which is what those of us who in higher education are involved in and so forth. So Roger mentioned neoliberalism. I've published on this recently with Edinburgh University Press, and I try, even though I don't use the word decoloniality, it's going to be in my next book that's in process right now. I try to show how what we call decoloniality and neoliberalism, even though they aren't the same thing by any means, they do, in a sense, come from the same epistemic way in which we've structured knowledge. So we have to, again, hopefully, as we go through these discussions, look at ourselves, be reflective in totally the opposite way that Descartes did in the 16th century. Descartes being the sort of architect of modernity and modernist thinking, when he said, I think, therefore I am. Perhaps we need to say, we talk, we communicate, therefore who are we? Who is each one of us, and so forth. It's this, what Wynter talks about is relational knowledge. And I know that there are others who will be talking about that. What Wynter says is that the modern episteme, the modern way of knowing, is an overrepresentation of the world as it is experienced from different sides. In other words, the colonist meets the indigenous person who becomes the colonized, and the colonized way of seeing, the colonized way of talking, the colonized way of self-knowing is bifurcated from the colonizer's way of knowing. W.B. Du Bois, in the beginning of the 20th about the dialectic of double consciousness, particularly among colonized people. Ron Spanone picks this up. Famous essay from the 1950s, Black Skins, White Mass, and so forth. So this kind of duality, this duplicity, if you want to call it, this double consciousness is something that Winter talks about is not recognized in what she calls the overrepresentation of being by the modern world. So for her, knowledge is something that comes from both sides equally, not where those who, in a sense, have been forced into the modernist episteme now have to talk in terms of the modern episteme. But how do those who are brought up and have taken for granted that episteme, how do they listen? Vine Deloria, in a book that he wrote many years ago, was titled We Talk, You Listen. He was talking about Native American peoples talking to white people. It's like, not we're going to listen to you or we're going to have a dialogue. You're going to listen for the first time to us. So hopefully we want to bring voices and make visible and give voices in a powerful way in this conference to people who have not been heard, who have been filtered through the modernist Western episteme, and begin to start a whole new conversation about the nature of knowledge itself. All right, so those are just my personal remarks, and we kind of wanted to frame this provocatively, or perhaps for some of you this is provocative, or maybe it's not provocative enough. But I'm going to turn now to Roger, who's going to introduce the first presenters in our program.
Thank you, Carl. I think I saw Andy pop in. Sheldon, are you online yet? Andy, are you here? I can't see everybody.
I am.
Okay.
Good morning, Roger. Good morning, good morning, Carl, and good morning to everyone else.
Okay. I'm going to read your bios out, and maybe Sheldon will have popped on by then.
I'm on.
You're on? Okay, there you are. Good to see you. Good morning. Okay, so our first session here is going to be Sheldon's Spotted Elk. And we do this, a little bit on purpose, right? Because Sheldon, being from the Northern Cheyenne tribe here, we want to give you kind of first voice this morning, Sheldon. So Sheldon Spotted Elk has a background and presents regularly on tribal law, child welfare act, and the Indian Child Welfare Act. There was a major decision on this last week, actually. He is currently a judge on the Ute Indian Tribe Court of Appeals in a jurisdiction he once represented children in what child welfare and juvenile delinquency matters. He has worked as an adjunct professor teaching a law school course on family law in Indian country. He was recognized as a NCAIED 40 under 40 recipient, a prestigious award which recognizes 40 emerging American Indian leaders from across Indian country. He's published an influential law review article on tribal constitutional reform and has authored articles on the Indian Child Welfare Act. And he and his two sons are members of the Northern Cheyenne tribe, Lame Deer, Montana. Andy Yost, or Andrew Yost, sorry, I went to grad school with Andy. Dr. Yost is an attorney with the Federal Children's Bureau Capacity Building Center, or CBCC, for courts, where he leads the national effort to support application of the Indian Child Welfare Act in state court child welfare proceedings. He is also a philosophy and religion lecturer at the University of Colorado, Denver. His research interests include the phenomenology of love and the imagination, romanticism and the disenchantment thesis, and the decolonization and the law. Welcome to you both, Andrew and Sheldon.
Thank you, Roger. Appreciate it. So am I going to go first, Andy? Is that what we're... All right. So I'll say in Cheyenne, Pivawana. So that's good morning. Teach you guys a little Cheyenne. So the response to that is Piva. So you say good. So I say good morning, you say good. So next time and also the Cheyenne handshake, it's a sideways karate chop. And you put your thumb at your heart. And you come out. So you could say, when I say Pivawana, you could just say it through your screen, Piva. So next time you're walking down Cheyenne Avenue in Lame Deer, Montana, you're strutting down the street and somebody comes up to you and say, Piva whatnot, you could respond back and you could look like a local Cheyenne. So I'm here to talk to you a little bit about child welfare. And I think it's important for me to, hey, somebody knows, Piva, yep. So I'm going to talk to you a little bit about children. And when Cheyennes talk about children, that is something sacred. And hopefully I'm able to couch this in the appropriate way of Cheyenne law. So I do want to talk to you a little bit about Cheyenne tribal law. And then I'll talk to you a little bit about federal Indian law. And of course, that's colonial law, the colonial legal system that is colonized tribes. There's 574 federally recognized tribes. So these are tribes that the federal government of the United States has said, all right, you guys get your official membership being a federally recognized tribe, and there's a process to become a federally recognized tribe. So I'll talk to you a little bit about that as well, but it's most important for me to couch what I say within my tribal tradition. And I'm fortunate, also important for me to give you this introduction, that I'm the fourth child of 6 of Navid and Maxine Spotted Elk. And so my dad grew up Cheyenne with a Cheyenne worldview, didn't speak English until he was 5, went to school. And I sat at his dinner table and heard stories. And I'm going to tell you one of those stories that I heard as a child. And then in turn, I told my children. And it's a story he was told as a child. And it really is important for us to start that way. Because when we talk about children, it is ceremony. And so hopefully we could do this session justice. But also, I'm the great-grandchild of Charles Spotted Elk. And he's the OG, he's the original gangster Spotted Elk, Moe Huais, how you say Spotted Elk in Cheyenne. That was his Indian name, Hoish. Moe Huais was his Indian name, Charles Spotted Elk, English name. But he was orphaned at the Sand Creek Massacre when he was 2 years old. So that's a massacre that happened in Colorado that killed 200 Cheyennes on a morning of November 29th, 1864. I was also told that story when I was a child, and it definitely had big impacts on my family. Every year they do the healing run, the Sand Creek healing run, spiritual healing run, that starts in Sand Creek, and we run to the steps of the Capitol building in Denver. It's about 180 miles, and we do a relay run. During that run, we meditate, and of course, there's so much spirituality and connection you get with the earth when you run and breathe really deeply and heavily, and and get all that good oxygen in your lungs, and you can really think and meditate upon what healing looks like. And that is an event that still, and I bring that up because that's something we still are healing from. We're still trying to create some sort of medicine to have some healing and be able to move far on from. And it has deep impacts on my families. My grandfather, August Spotted Elk, went to a boarding school. He was forced to go to a Pipestone boarding school, which is no longer in existence in Minnesota. I think it's interesting. I was told about this when I was a child. Like, the way that it was couched to me, it was like something really amazing. Like, oh yeah, he went off to boarding school. He learned how to do carpentry there. Like, it was a really cool thing, like it was kind of told to me because I think my dad was trying to protect us. But it was kind of told to us in that way. It was only my uncle that told me, my truth-telling uncle, that told me that it was a devastating thing for him that he was forced to go there when he was 8 years old. And he lost his best friend when he was like 12, 13 years old. His best friend in the whole entire world that was at boarding school died there and never came back home. And that's a significant thing for American Indians is is that there was a boarding school forced assimilation experiment that happened here, where they tried to, the express policy of that was trying to kill the Indian to save the man. And so hard efforts were at play to change the way that we look at the world, the way we value our knowledge, the way that we value family, the way that we value the law. So I also want to recognize that and some of the things that I'm saying. But even just last week, I went and saw my dad, and he actually, it was really great. He put up, it's important for him to teach us. And so I learned a lot of cool stories at my dinner table, like I said, and in the backyard of my house growing up. But he's staying with my oldest brother now, and he had all the grandkids go out, and he wanted to show everybody how to set up a Cheyenne teepee. And so that was really, it's still important for him to make sure that knowledge is passed on. And so that just happened last week. And he revealed to us, because he's given us a little language lesson in there with his grandchildren. He was like, he revealed to us, and he tells a story, once again, probably to protect us. He kind of tells it with a chuckle and tries to make it funny of how his mouth was washed out with soap because he didn't know English, and he actually struggled with English. And so his mouth was washed out with soap when he was 6 years old. And so there's definitely a devastating psyche that impacts our families and impacts children. There's historical trauma that has definitely impacted our communities because of these things. The express genocide of the United States against the American Indian. I guess Cheyennes included. Is somebody off mute? Getting some background noise. But I want to fast forward really quick, and I'll make this short. I promised you this. Can you hear me now? Okay. It's important for me to start this way. So I'm going to show you this cool picture here. This is ledger art. For those that don't know, this is, we didn't always necessarily, Cheyennes didn't always have disposable paper at our whim. So whenever we met cavalry officers or federal government officers or people with paper, oftentimes ledger books that kept and helped people balance money and things like of that nature, we started creating art on it. And now there's a whole genre of art around ledger art. So this is really popular now. You could go and buy ledger art that's contemporarily produced. But this is a cool picture here. It's a depiction of the Great Race. And so this comes out of the Tie Creek ledger book, which is, I think, 1880, if I'm remembering right, but I might be wrong on that. But around that time, 1880, 1890. And this is the story that I heard as a child. And in turn, I've told my children a million times. They could tell you this story, and I'll make it short and sweet. So long time ago, we lived in harmony with the animals. So we all had the same economy. We all ate the same food, and we lived as one people. There was a drought that came. So it was changing the way there was a shortage of resources, and it was changing the way that we were living. So we met with the leader among us was the buffalo, actually. So the buffalo came and called a big meeting, and we were representing the two-legged, us, the Tista, the human beings. We were representing the two-legged, and we went and met with Buffalo, and Buffalo says, there's a shortage of resources. We have to do something else. We're going to do a big running race. We're going to run around the Black Hills, which is the center of the Cheyenne universe. We're going to run around the Black Hills in South Dakota 4 times. That's a sacred number for a lot of tribes, especially Cheyennes. So we're going to have 4 laps around the Black Hills, and whoever wins that wins responsibility. I'm going to come back to that. So they win responsibility. So they are stewards of the land. They're stewards of all living things. And so we began that race, and they said, ready, set, go. And we ran as fast as we possibly could as two-legged. The birds were on our team since they have 2 legs. And immediately right off the bat, Magpie, we tried to have a plan to run together. Magpie just flies all the way straight up in the sky, and he disappears. And we're like, oh man, he completely betrayed us. But we tried to run as fast as we can. But because we only have 2 legs and we're pitiful human beings, and animals have 4 legs, they were 2 times as fast as us. And so fast forward, we come around for the last turn of the 4th lap, and it's doomed. We're going to lose. Buffalo's way ahead. And you can see all the animals in this picture here. You can see all the animals that are being represented that are running in this race here. And it looks like we're doomed to lose. But at the last bit, Magpie, in this picture here, Magpie swoops down and he wins the race for the 2-legged. And because of that, Magpie eats meat. And we have a sacred relationship with magpie. We don't kill magpies. We don't eat magpie. It probably wouldn't be that good because they're scavengers. But we don't eat magpie. We do use their feathers for mostly peyote ceremonies, Native American church ceremonies. But we have the sacred relationship with magpie. But we won responsibility there. We made a promise, a vow in that ceremony, that we were going to be good stewards of the land. We were going to be good stewards of humanity. We were going to make sure that the earth had enough food and we weren't going to pollute the earth so we all could live in harmony. I failed to mention before that race, part of what Cheyennes, when we do ceremony, we paint. So that's the difference, probably the big difference between Cheyenne Sundance and other tribes at Sundance is that we wear paint during our Sundance. And so before we did this race, we all put on paint because that was our vow. That was our promise that we were making when we did this ceremony. So Bald Eagle, of course, painted his head white and his body brown. Buffalo painted his coat brown, his hump dark brown. So all the animals painted themselves. And us Cheyennes, we painted ourselves too. We painted ourselves with the earth. So that's why we have brown skin. It's a great, just like our mother Earth. And so where we see this happen today and why this is relevant in 2021, at the very beginning of the Sundance, the first thing that they begin before one song is even sung, after all the dancers come in, and traditionally I understand it was orphans that would go and make small figurines, little animals that represent the animal in the dance out of clay. And so the orphans of the tribe that belong to all of us, they have a special place in our heart and a special place in ceremony, is that they would come in and be blessed by the Sundance chief and place those little figurines of those animals at the very base of the Sundance. So that happens in 2021. When this Sundance happens this summer, that's how that will be kicked off, and it's symbolic of this Sundance. The last thing I'll say, and I'll let Andy talk a little bit because I know I'm talking a lot right now. The other cool thing that in 2021, when you are walking down the street of Cheyenne Avenue in Lame Deer, Montana, you will see young children. And I used to have long hair, but now I have this short haircut now. But you'll see young children with 5 braids, and there's some symbolic metaphor to that. There's some power and medicine to that. The 5 braids is that they have 4 in each direction. And so the 4 directions are sacred number 4. And then that 5th braid actually comes out of the very tip of their head. And it symbolizes their connection to the divine. We have a word in Cheyenne for that. Gutchguni is how you say children. Mahio Gutchguni is what we refer to those children. And those are children that are younger children, probably 8, 9, 10 years and younger. Our Mahion Gutchguni, that means their creator's child. We all have a sacred obligation to them. And so we have reciprocity with those children. And just the fact that they're here on this earth, they're blessing us. Just the fact that they're here, they're a miracle. They're blessing our lives. So they don't have to do anything except show up. When they get a little bit older, then they have to start doing stuff. And by that time, they just show up, the blessing to us. And we have a responsibility to reciprocate that blessing and take good care of children. All of us do. So if we couch, and I'll come back to this, but if you think about this, what I just barely talked to you about right there, that's law. I just gave you some Cheyenne law right there. And fundamentally what we're talking about is storytelling. Euro-Christianity is a story. America is a story. And so a lot of people believe that story, actually. A lot of people believe these stories, and so when we talk about Cheyenne law, it fundamentally comes out of as a story. I think there's a big difference between the way Cheyenne and indigenous peoples see story because I think we see it as explicitly a metaphor or allegory, where I think sometimes, especially fundamental Christians or fundamental religious people will often see their story as the literal truth that frames their world, and it makes them sometimes do really bad things, like manifest destiny, like force children to go to boarding school, like kill other people that don't look like them or believe like them. So, but I think fundamentally when we talk about story, I want to frame what I say further in this discussion, count very squarely in Cheyenne law. And this picture is a great depiction of that. So with that, I'll turn it over to Andy. That's kind of my opening. Hopefully that hit the mark, Andy.
See, this is why I always regret choosing to work with Sheldon. Because there's a lawyer from one lawyer to another. Good luck matching that opening statement. So let me just say, first of all, thanks, Sheldon. That's always a pleasure to listen to you speak. And thanks to everybody for joining us this morning. I'm humbled to have the opportunity to work with you. Let me just say, as a matter of logistics, I'm hard of hearing, and so I have a headset on. Roger, I'm going to look to you if my audio is bad. I also have the misfortune, maybe you could say, of living in the world on 2-year-old time. I have a 2-year-old at home, so I can't work from home. So I'm in this weird liminal space where I have to work at a noisy coffee shop, being hard of hearing with the headset on. So if it gets bad, let me know and I'll just mute myself, and Sheldon, I'm sure, will be able to cover for me. So Sheldon, I appreciate you passing the mic on to me, and I certainly have some thoughts that I'd like to share with the group in response to this kind of prompt that we've created for ourselves of how do you do it as a lawyer, it being engaged in decolonial praxis and decolonial thinking, decolonial activity within the context of American jurisprudence, generally speaking, and more specifically within the context of child welfare law, and then even more specifically within the context of the Indian Child Welfare Act, which is a federal law that governs when an Indian child is removed from their home and placed in foster care. It adds some heightened protections in those circumstances. So my comments are going to be in that vein. And just in terms of positionality, you know, I'm a middle-class white guy. I'm trained in the academy. I have a PhD in the study of religion, and I have a JD, obviously, because I'm a lawyer. So I'm tried and true Euro-Christian in terms of my positionality. And my hope today is to explore with you generally as a group, and obviously with Sheldon in particular, the question of how, if at all, it's possible to engage in decolonial practice within, and I want to emphasize that how, if at all, it's possible to engage in decolonial practice within American jurisprudence, and in particular, sort of conceiving Sheldon and I's positionality as lawyers practicing within child welfare law within the American legal system. So that's sort of the angle that I want to take, is how do you do it as a lawyer if you can at all? Before I dig too much into that though, Sheldon, I hope you don't mind. I know we didn't talk about this, but I'm going to just put you on the spot. I wonder if you might say a little bit about what I think of as kind of the borderland that you and I share, which is the practice of American law and child welfare law. So, you know, I'm on sort of like the Euro-Christian academic legal side, and you're on the indigenous legal side, but also obviously have training in American law, as you're a lawyer yourself. So I'm wondering if you could just say a thing or two about how you and I operate within the context of American jurisprudence. Maybe another way of asking my question is, how do you distinguish between things like federal Indian law, tribal law, and the American child welfare legal system? Can you just kind of put some context in there, and then I'll jump back in?
Yeah, thank you. I'll correct something that, and I think I was on the last New Polis conversation that we did have, and I know somebody started off, and I believe it's Tink Tinker talked about, and there is a shortage of American Indian lawyers, and so there's a big shortage of American Indian lawyers that are practicing law in this country. We do represent less than 1% of all lawyers in the United States, and that's under our proportionality in the general population. And so But there's an annual conference that happens every year. It's called Federal Indian Bar, and it's talking about federal Indian law. And when we talk about federal Indian law, it comes out of primarily, I would say, three sources. And so it comes out of congressional acts, comes out of Congress. So they'll make a law like the Federal Indian Law, Indian Child Welfare Act. It's a federal law that was passed in 1978. And so that's a source of federal Indian law. Executive orders, those are sources of federal Indian law. U.S. Supreme Court decisions. And then squarely, the U.S. Constitution does frame the way that we think about federal Indian law today. And so I know we're talking about colonization. You think about that in some very significant ways. The U.S. Constitution, the Commerce Clause in Article 1, Section 8, Clause 5, or whatever it is, it does mention that Congress shall have the power over trade, commerce from between other countries, states, and Indian tribes. And it's from that there's famous three cases that were ruled on in 1823 to 1833. So in that 10-year span in the early 1820s, 1830s, called the Marshall Trilogy, who was the Supreme Court justice at the time. And it's from those three cases, and I won't labor what those three cases were about. Two of them are very disgusting and very gross, and actually they make you read Johnson v. McIntosh, which is a property case between two white guys fighting over who has title to the land. One guy got his title from the tribe, the Piankashaw tribe, which is an extinct tribe now in Illinois. And this other white guy got his title from the federal government, and they're making an argument of who has the right title. And they make all law school students read that. Well, most law school students, it's in every law school property book as the first case to read, because it disturbs your universe when you read this case. But from the from the Marshall Trilogy, there's four principles I want you to think about when you think about, I know I'm giving you a lot of numbers here, but these four principles that you think about when you think about federal Indian law. One, and we get this from those three decisions. One, limited state power. So states have no power to make laws or jurisdiction over tribal lands. So limited state authority on tribal lands. Two, Congress's trust responsibility that Congress has with tribes. So, and that was formed in those early decisions. Tribal sovereignty, I know that was a discussion. So there is something unique about tribal sovereignty and tribes as governments. So we have our own court systems. Of course, I moonlight as a Court of Appeals judge in one of the tribes. I worked for a tribe. I've worked for a few tribes actually, and maybe I'll talk a little bit more about that. And then the fourth thing, which is not really relevant today, is Indian property, is that tribes do not have the ability. In property law, they talk about laws, property as a bundle of sticks, that you have the ability to, if this pen right here is mine, I own it, I could trade it, I could sell it, I could lease it. There's all these different things that I could do with this pen since I own it. But Indian property is unique in the sense that we lack one of the bundle of sticks. It's the ability to sell it. So we have the inability to extinguish, to be able to sell the title. And so that's what that first case is about. But when you think about federal Indian law, that's the distinction. And in my experience, I went to University of New Mexico School of Law, great professor there, Christine Zuni Cruz, who is a mentor of mine. She produces a journal called the Tribal Law Journal. The article that I wrote about tribal constitutional reform that was written in the Tribal Law Journal. But it's interesting to me is that we need to train lawyers, because all lawyers, and even the indigenous lawyers, even tribal lawyers that are practicing law, we have to teach them actually what tribal law is, not vice versa, because everybody has that framework that they're doing federal Indian law, and that federal Indian law fundamentally is about that push-pull relationship between the feds, states, and the tribes. But when we think about tribal law, it's what I just talked to you about today. It's about the great race. It is that story. And do we codify that? Do we put that into code? So if there's a child that's being abused or neglected right now in Northern Cheyenne, and the parents are brought into tribal court for that issue, is it framed on Cheyenne traditional values, or is it framed on the Social Security Act Title 4E, which kind of dictates how a court hearing will happen in state court? So those are issues that tribes need to confront and face. In my experience, those are issues that I have faced and confronted in 2021 and continue to face and confront in 2021. And so just being able to cut and paste state law and put it into your code, we need to be a little bit more thoughtful about that as tribes. But of course, we haven't had that, like the story of tribal sovereignty. There's privilege that comes when we say sovereignty in a Western sense. There was such privilege that came in it, like when we even tell the story about the United States, there was this convention that happened, like these guys came together in Philadelphia, and it was a really hot room, and they wrote down some values, and they wrote Federalist papers about, and they discussed and argued about what areas should look like. When Cheyennes were given our Constitution, the Indian Reorganization Act of 1932, it was a fill in the blank. It was the feds coming in saying, you guys need a Constitution, and put your tribal name in all these places, where there's 28 references in the Northern Cheyenne IRA Constitution that says we need Department of Interior approval on 28 different things within our Constitution. And so for us to be thoughtful about that and removing those areas, and some tribes have done very successful job. But also to the question in tribal law, so hopefully I've done a good enough job of making this bifurcation. In tribal law, what are our values? And maybe those values don't need to be codified. Maybe our Constitution is our Sundance.
Oh, sorry,
Maybe it's that ceremony that happens every year. And that's how we recognize what our value is within that story that I just told you. There's some values within that, and we don't necessarily need to write those down and codify them. But just some of those things that we need to think about. Of course, I'm a lawyer and trained in that. So my bias is always like, let's write it down and argue over it. But of course there is a diversity of perspectives, and of course I'm open to that as well. So is that what you're hoping for, Andy? I could add one more thing if you'd let me. All right, give me the okay. Christine Zuni Cruz, and I think this is important for us to also talk about. She talked about, and I don't even know who she's citing on this. Maybe I'll find the source on this. But she talked about legal traditions of the world, and so there's a legal scholar that wrote about it. And so, of course, there's the common law legal system. There's the civil legal system. There's the Talmudic. I think I'm saying that right. I've only read it. Legal system. There's Sharia legal system. There's a legal system that's called chthonic legal system, and those are people of the earth, people that live ecological lives. And so, broadly classified, tribal law, traditional law would fall within that big system. And there's people that have studied chthonic legal systems. Christine Zuni Cruz, my mentor, Isleta Pueblo woman, she's somebody that studied those legal traditions. And if you think about some of those core values in there, one of the most fundamental things is, how do we define who we are? A member. Who is a member of us? Who is a citizen of us? And of course, if I know we have some people here from Denver University of Denver. If I wanted to lie and say, hey, I went to University of Denver, and you would be like, oh, really, you did? So I'm here I'm lying, I'm making this up. You would find out really quick that I'm lying, actually, because you would ask me, like, hey, did you go hang out at the football games? Or maybe that's the big one, because is there a football team at the University of Denver? So you'd find out really quick that I'm lying, So you'd find out really quick that I'm misrepresenting that truth. And so how do we define us? And what is us, and so if that's it, if alumni of DU or people that work at University of Denver, like what makes us us, and how we define that. But for tribal people, there's a lot of different things there. And they talk about, in chthonic legal systems, they talk about kinship. So your relatives, your brothers, sisters, aunts, uncles, ancestry, who's your mommy and your daddy and your grandpa and your grandma. Fundamentally, when we talk about tribes today, blood quantum and descendancy, the two primary ways that tribes say who they are, those are the two primary ways that tribes today say is who's your mommy and your daddy, you know, who's your grandma and your grandpa, you know, like, and maybe I don't know, maybe I lack creativity, but I think maybe that's the only way today that we could get people that are close and connected to the community and close and connected to values, is about who's your mommy or your daddy. But other ways about speaking a common language. Of course, colonization has taken language away from us in some ways by putting soap in people's mouths and forcing them not to. Cosmology was another way. What happens to us when we die? There used to be uniformity around that. You know, there used to be some existential uniformity that we as Cheyennes had, but since Mennonites came to our reservation, Jesuits came to our reservation, Mormons came to our reservation, and so you have a blending of all these Christian traditions that are within the Northern Cheyenne. There's people that are still very heavily traditional. Native American church, my dad was a practitioner of that, but he's also a sun dancer. But he has this blended, probably unique religious view that nobody in the world has like him. So he's a member of one church. He's the sole member of his own church, you know, so like of this blended view. But when we think about chthonic legal systems, those are the most fundamental questions that we're asking. Is about how do we define ourselves? I urge and think that that also influences the way we define family, the way that we define how we take care of and the responsibility to take care of children, that stewardship that I was talking to you about in that story. Last thing, and I promise I'll turn it back to you, Andy, as we juxtapose that to the federal ICWA, and I'm going to share my screen one more time. I have to show you this cool picture to tell you about this. So this is me in Manhattan, right across from NYU, New York University Law School, and I'm having dinner. Well, it started off as lunch, and it turned into dinner. It was one of those 5-hour lunches that sometimes happen. But guys, right here is Jack Trope, who I work a lot with. He's a lawyer. And Bert Hirsch, and he's one of the 3 lawyers that put pen to paper and wrote the Federal Indian Child Welfare Act. Creative lawyer. At this dinner here, it's nighttime, and he leans over to me, and he finally, like I listened to him talk about his stories, how he barnstormed east to west, north to south, represented parents, Indian parents before ICWA, and would beg, borrow, steal, practice law without a license in a lot of jurisdictions. Just fought, was just an advocate of children and families, and fought the hard fight and had the battle scars to prove it. And then worked for the Association on American Indian Affairs in New York, and helped write the federal Indian law, or federal law, Indian Child Welfare Act. But he told me in this, and of course, I think there's values within ICWA that mirror, that are very similar to tribal values. But what he told me here, he said, "Hey, Sheldon, do you ever do trainings on ICWA?" I say, "Yeah, I do a lot of trainings on ICWA. I train all the time on ICWA. At this time, I probably did 10 to 15 trainings per year on ICWA. But he said, "Do you know what you need to tell people? You need to make sure you tell people that ICWA is reparative. It's the only law on the books. It's the only child welfare law on the books that's reparative. It was written from that frame. And if you read the congressional findings, that 25 to 35% of all American Indian children were placed out of home. Think about that for a second. 25, 1 out of 3 children, American Indian children, were removed from their natural home, their natural parents, and placed into foster care when ICWA was written. 90% of those children that were placed out of home were placed with white families. Assimilation happened, and this is not long ago. We're not talking about ancient history here. All of us were probably alive. Most of us were alive when all this was happening. And so this law is written from that lens of repairing, trying to create some sort of justice. And I think there's a unique view of that in tribal traditions as well, of justice, what that looks like. That's way different from Western values. And that's a whole nother conversation altogether. But the short of it is, it's more reciprocity based than it is rights and responsibility based. If you read any law, you'll find that there's some rights holders within a law and there's responsibility holders within a law. Usually governments are responsibility holders and usually citizens are rights holders. And it's based upon individualism. But for tribes and tribal people and communal people, there's more reciprocity. How could I force you to do anything? You know, how could I make you do anything necessarily? You know, like, unless there's goodness and love that's present. And so justice is fundamentally married with love, in the Cheyenne sense. And maybe that's just me as a romantic saying that, but that's what that's my argument. And that's a whole conversation for another day. But I'll turn it back to you, Andy. I'm talking a lot, I know.
Thanks, Sheldon. Yeah, that's really helpful. I think that especially that legal context is useful for folks that aren't kind of day in, day out slogging away at the Indian Child Welfare Act. I think it's nice to be able to locate that specific piece of legislation in this broader national discourse and national legal system. So thanks for that. So I want to just sort of position myself in relationship to Sheldon and then this broader conversation about decoloniality and what that means for us as attorneys, or I don't want to speak for Sheldon, but what it means for me as an attorney, sort of raised and trained in Euro-Christian institutions in the environment. So first, let me just acknowledge the fact that I sit in a coffee shop in Denver, which is the land of the Arapaho, the Apache, the Comanche, the Ute, the Cheyenne. And so my position right now is an orientation. I see myself as speaking back to the institutions that I was trained within. And so sometimes I have this fantasy idea of like standing back to back with Sheldon in the work that we do, where he is able to speak both to the system in which we work, the American legal system, and also within an indigenous community. But my orientation is sort of looking back toward the institutions from which I came, so to speak, or in which I'm embedded. So I just want to be clear about sort of the provisionality of what I'm about to say, the sort of intellectual and existential location in which I find myself. And of course, that comes with a ton of limits, but also generative opportunities, I think, that I'll talk about as we move along here. Because I am going to get kind of laser focused, I think, just knowing myself psychologically, I will keep an eye on the chat when I can. But Sheldon, if you see something that I need to say, yeah, if you'll just, we've worked together long enough, you just let me know.
I'm in the chat right now, though, too. So don't be distracted by me posting there.
Okay, cool, thanks. So again, for me, the question here is, and I have to thank Dr. Green for posing the question with sort of an elegant simplicity. How do you do it as a lawyer? How do you engage in decolonial practice as a lawyer? And when I say the word lawyer, I'm not thinking about a lawyer. I'm a different kind of lawyer than Sheldon is, right? A lawyer within my own positionality as a Euro-Christian, Western-trained attorney, and also academic. So what I like about that question, what to me is elegant about that question, is there's sort of two do's, right? How do you do it as a lawyer? And depending on how I inflect, as I have reflected on this question, depending on how you inflect that question, I think has drawn my attention to at least two different dimensions to the way I might answer that question as an academic and a lawyer. So the first inflection, I would say, is an inflection on the second do, right? How do you do it as a lawyer? And for me, that's an inflection toward praxis. So this is more in that Walter Mignolo, Catherine Walsh kind of vein of thinking, right? Like, what does it mean to actually take on a form of life that is engaged in the practice of decoloniality, right? To use Mignolo's language, delinking from that system. So I'll come back to that in just a second. But for me, what my point is, I want to emphasize that the simplicity of the question, how do you do it as a lawyer, there's a lot of richness in the way that question is posed, because that second do is, for me, inflected toward praxis. And then that first do, how do you do it as a lawyer, right? If I inflect it that way, to me works on sort of the meso or maybe even the macro level. So for me, that's one. I'm reluctant to use the word theoretical, but it at least operates on a philosophical level for me, which is a question of limits and possibilities. Like, How do you do it as a lawyer? So I'm going to just frame my comments according to those two inflections. So I'm going to toggle back and forth between them as I go, and I'll let you know which one of the two inflections I think I'm working on. And of course, you can correct me or refine my thinking as I go along as well. So with regard to that first inflection, how do you do it as a lawyer? It's sort of at the conceptual level. How do you do it as a lawyer? I can think of at least a handful of ways that you might answer that question. The first one is you can't. In other words, you can't work within a colonial / modern framework and engage seriously in decolonial activity. In other words, the water in the well is already too tainted, right? That there has to be some kind of fundamental breaking away from modernity as a norm and working within any kind of Western grounded jurisprudential system is always already broken. So I just want to acknowledge that's one possible answer, that like I can't actually do anything from where I stand in the world. And Sheldon and I sometimes laugh about how limited your power is as a lawyer. I think at least in the Western mythos, everyone thinks, oh, lawyers can do anything. Someone's mad at you, you send a letter from a lawyer and the problem goes away. But in a lot of ways, we're not that useful in this work. And I think that has to do with a lot with our training, which comes from a colonial modern construct or paradigm. So I just want to acknowledge that perhaps the answer to the first inflected do is you can't actually do anything, which can be unsatisfying, admittedly. For me, I think on my worst days, and I know Dr. De La Torre has has thought this through in ways that I have not, but it feels hopeless to me. And perhaps it is, and perhaps that's a good thing. And perhaps that creates a generative opening that a sense of hopelessness a sense of hope cannot create. So I just want to acknowledge that that's the case. But I also will admit that I'm not sure I've come down on that side yet. For me, it remains an open question. At least that's what lets me get up in the morning and shoot Sheldon an email and get back to work. But I'm acknowledging the fact that I might actually be just wallowing in the abyss here. So one possible answer is you can't do it. Another possible answer, and I think this is probably the predominant one, at least in my day-to-day work as an attorney working in particular on the Indian Child Welfare Act and with tribes more broadly, is that you can do it and you should just do it. In other words, I see this answer of like, how do you do it as a lawyer? How do you engage in decolonial practice as a lawyer? This is kind of like what I would call the neoliberal identity politics version of the answer. So this is the one that has kind of I'm going to call it a pop militancy about it. So this is the one that says something like, this is the mainstream political discourse in America, right? This is most headlines on CNN, for example. This is the discourse rooted in concepts like white privilege, white supremacy, white fragility, which in my opinion, and I guess I'm at an academic conference, so I'm here to share my opinion, lack the kind of intellectual rigor and reflection that yields the kind of fruit that I think we want to yield if we're going to actually engage in decolonial work. And I want to acknowledge the fact, I do believe that the question of identity politics is a really, really rich question. It warrants serious philosophical reflection. There's a lot of really interesting work around identity politics and what it means as a strategy. So I'm talking more about that kind of mainstream popular culture form of identity politics as a possible answer to this question of how do you do it as a lawyer. It's the person, I'll just give you an example. I won't name names. You don't know them anyway, so it doesn't matter. But it's the person who, when me and Sheldon and 3 other people are working on a project with a tribe, just sort of snarkily types into the chat, the system is racist. Okay, like fair enough. I think that's an important point to make, and it's one that we need to take seriously, but there's more work to be done in that vein of thinking is sort of my thought. So what am I getting at? What I'm getting at is if the answer to the question, how do you do it as a lawyer, is you just do it. And the implication there is that you do it according to the register of, or within the register of neoliberal identity politics. I'm not convinced that that's that's a valuable or fruitful way of going about the work. Let me just say two quick comments about that as well, and then I'll move on to the more, what I think is hopefully the more interesting part of my talk, which is how do you do it, and how do you do it as a lawyer? Just two quick comments about identity politics and sort of the neoliberal vein. One is, on my read of it, identity politics in the neoliberal vein tends to reinforce rather than upend the power structures that it purports to challenge. So for example, some of you are familiar, I'm sure, with Maurizio Lazzarato's The Making of the Indebted Man. And he does what I think is a fantastic analysis of how the mechanism of debt, the economic mechanism of debt, rises to the level of ideology and then operates as a concept of control, right? As a form of subjectivation, to use Foucault's language. And so for me, there's an interesting relationship between the language of debt and sort of mainstream neoliberal identity politics. So that's one sort of beef I have with it. The second one, or another one I should say, is this kind of like what I would call a secular ontotheology of the self. So this attempt to, we've done away with God, right? The death of God. And unless I'm interested in phenomenology as well. So there's this weird death of God thing that's going on in French philosophy, but we'll save that for another day. There's this kind of secular ontotheology of the self where we've pivoted, or at least the mainstream discourse to me seems to have pivoted toward grounding being in the truth of the self and the ontology or metaphysics of the self. So there's something there that I think is worth discussing. All of this is just to say that I'm not convinced that mainstream neoliberal identity politics in the current form that we see it in terms of like CNN and Signs Outside is the right method to engage in decolonial practice in the American legal system. So what's another answer potentially to the question of how do you do it? For me, another answer is you can do it, but it takes a lot of tact and a lot of humility. And unfortunately, I think for me, and just my own idiosyncrasies, maybe limiting my ambitions a little bit about what work I can do, again, given my positionality as a lawyer trained in the environment in the way that I've been trained. So let me give you an example of what I think that third answer might look like. And then I'm going to focus specifically on the second inflection. So how do you do it as an attorney? And I'm going to borrow heavily from Mignolo and Walsh's work. So hopefully that'll start to lay out some of the conceptual tools that we can use going forward over the next few days. So there's this really interesting work being done. Oh, I'll admit, I'm a romantic at heart. And when I say romantic, I mean capital R romantic. I also am small r romantic. That's the philosophy of love stuff talking in me. But I'm talking now historically, capital R romantic. So, the long 18th century, 1750 to 1850-ish. I'm a Wordsworth fanboy. I'll admit it up front. And I'll take all of the heat that you want to give me for admitting that. But I love it. And I just can't get enough of the stuff. There's some really interesting work going on in Romantic studies in what's called Black Romanticism. So Paul Youngquist and Francis Botkin are two academics who are doing what I think is some really interesting work in this arena. And basically what they're doing is well, I shouldn't say basically, they're doing a lot of things. One of the big things that they're doing in their work is they're shifting the way that we tell the story of Romanticism away from the island, Britain, toward the Isles, the West Indies. And rather than seeing the West Indies as a space on the margins of Western Empire, what they're actually getting at is saying that it's they have really great language, by the way. They're the kind of writer that I'm jealous of, that I always aspire to be, but always fail to actually be. They argue that the swirl of the Atlantic is actually the engine that drives, or that drove, British Romanticism in a particular case study of the broader Romantic movement. So it's super interesting work. Why am I bringing this up? The reason I'm bringing it up is because for me, it's an example of that answer 3. How do you do it as a lawyer? I'm saying it's not as easy as identity politics. It's not as straightforward as you can't. I want to say that you can do it, but it takes a lot of tact and humility. And I'm offering up this Black Romanticism as an example of how there are scholars trained in the Western tradition working within the academic institution of a university who are engaging in decolonial scholarship within that institution. Interestingly, both of them are middle-class white folks, and they are well aware of that, but have found a way to create a space within the institution to, well, to use again Mignolo's language, to create spaces that affirm life, or that are advanced forms of life that are not in service of an institution. So I'm just going to read, I know this is like the big faux pas in a conference where you're supposed to be engaging and charismatic, but I'm just going to read a couple little quotes because I want you to get a flavor of what, to me, this sounds like within Romantic studies. So here's something that they say. The whiteness of Romantic studies is a symptom of amnesia. It bespeaks a massive act of forgetting on the part of contemporary scholarship, an institutional disavowal of the economic conditions that helped make cultural production during the Romantic era possible, the maritime economy of the Atlantic. And one more beautiful little line here. Replacing British with black allows us to dislocate Romantic studies, literally. We move the ruling perspective from critical inquiry from the island, England, to the islands, the West Indies. This is not, however, a movement from metropole to periphery. The West Indies are not the edge of empire, they are its engine, as I said earlier, the economic, material, and cultural condition of British prosperity and dominion during the Romantic era. To chant Black Romanticism as a means of conjuring this ancestry is to honor the Atlantic as its presiding genius. The Atlantic, watery vortex of myriad economic and cultural exchanges, roaring multiplicity of agencies, vast whirlpool of creative powers. So, you know, beautiful writing notwithstanding, the point to me is a very salient one. And the academic move that they're doing within the institution also operates at that macro level for me as an example of how you engage in decoloniality as practice within a Western institution. So I present that as one possibility among many. What I find particularly interesting about the Black Romanticism scholarship is that it is decentering in its approach, but it then declines to recenter, insofar as it's trying to challenge these underlying operative metaphors of centering itself. So it's playing with territoriality and deterritorialization and non-territoriality, right? The concept of the watery vortex and so on. So for me, that's a powerful intellectual move to keep in mind as I'm doing my own work as a lawyer. There's other work. Paul Gilroy's The Black Atlantic, Modernity and Double Consciousness. He does some of the same work around emphasizing mobility being no longer, his language is great, no longer rooted, but routed. So this idea of transformation and mobility being the governing analytical concepts that we use to understand what was once thought of as a Western phenomenon, British Romanticism, now in the vein of Black Romanticism. I think there are also legitimate critiques of this work, or at least it's worthwhile pointing out the limits of what's possible within this move, this kind of move, what I'm shorthanding now from British to Black Romanticism. It remains for me an open question as to whether or not this scholarship really rises to the level of delinking described by Walsh and Mignolo. I'm not sure it goes far enough. And again, this raises the question that I raised earlier of whether or not it's possible to go far enough from within the Western institution. So now I feel like I've set the table. I'm also nervous because I've been listening to myself talk for a long time. So I'm trusting Roger and Sheldon to give me like the Zoom body language that says, Yost, it's time to pass the mic. So let me bring this now back to the law for 1 second. I see that there's, well, let me actually look at the chat because I see Yost in there. Let me see. Yeah. Okay, fair enough. I'm gonna come back to the question of identity politics in just a second. There's certainly more to say about that, but that's actually not the thrust of what I wanted to talk about today. So I don't want to get too sidetracked on that, but it's a worthwhile question. So how do you do it as a lawyer on the first inflection? So now I'm focusing on that. How do you do it? Trying to draw lessons from the work of decolonial scholars that have already done a lot of thinking on this, as well as abstracting out some values and methods from Youngquist and the Black Romanticism movement that I just gave. So it's clearly a big question. You could have a whole conference on how do you do it as a lawyer. I think maybe we're doing that, so that's a good thing. Let me just point out sort of some double binds that I run into as a lawyer on that first inflection when I think globally about how do you do it. The double binds are directly related to what Sheldon has said. So let me give you an example. In our field, in child welfare law and federal Indian law, there's a strong push to recognize tribal sovereignty. And I'll use that word specifically, sovereignty. Sovereignty is a Western construct. It's predicated on the underlying idea of a nation state being the form of legitimate political formation and so on, right? There's a whole power dynamic that's built into that. My guess is most of us are familiar with that idea, so I won't belabor it too much. But the double bind is this. So we have interesting law in federal Indian law that is a growing body of law that recognizes and seeks to recognize what we would call tribal sovereignty in a lot of different domains, in the child welfare space, but not only in the child welfare space, in criminal law, in contracts, in what we would call international law even. So you take, for example, the McGirt case, which most of you know about, that recently came down. And it's a tough case, right? When I'm thinking about it philosophically and I'm thinking about it legally, there's a lot of folks in our world who see it as a major move forward, right? That we have this narrowing of the Montana kind of judicial common law phenomenon that's been going on, of where judges were kind of chipping away at, again, what we were calling tribal sovereignty before. And now we have this narrowing of who sort of gets to call the shots on whether or not a tribe's sovereignty has been disestablished. So that, on the one hand, seems like a good thing. On the other hand, it's a bad thing, because guess what? Congress is the body that gets to decide whether or not the sovereign, which already is a loaded concept, and tribe, which is already a loaded concept, gets to remain established, which is a loaded concept. So my point is that it's really messy, and it continues to raise the question for me of how do you do this as a lawyer? Is it even possible? I'm toggled between the perhaps foolish hope of Andy Yost, who wants more, and maybe the more realistic De La Torre position, who wants to acknowledge the fact of hopelessness. So I admit that for me, it remains an open question, but this is sort of how we kick it around. So whether or not, for example, the McGirt case actually is a step forward or a step backward, I think is a challenging question to ask. And I think a lot of ways the answer is going to depend on your positionality. Philosophically, I think I come down on the side that says it's not a significant step forward, in the sense of, and I don't mean that in the modern sense of history marching forward. I mean in a way less loaded sense than that. I mean in terms of decolonizing, or decoloniality, I should say, to be more specific. So just a couple more comments. I really appreciate everyone's generosity and patience so far. Just a couple more comments, I'll wrap it up, and then we'll let people ask whatever questions they want to ask. So this first question of how do you do it? For me, I think you have to do it with a sensitivity toward, for someone in my position, you have to do it with a heightened sensitivity toward the way in which the constructs that are floating around in the world that you're in and that are informing the way that you even sort of take the world in. That's the phenomenologist in me. We have to have like a heightened sensitivity and awareness to that. But also I think I have to do more than that. I have to sort of raise again and again the question of modernity, coloniality, and decoloniality, and the colonial matrix of power toward the institutions themselves. So for me, it's toward the American legal system. It's toward the federal government. And continue to call out the colonial matrix of power, again, to use these terms that are familiar to us. Another thing that I think I've learned recently that has been a difficult lesson for me to learn is that there's a big limit to what I can do. So when I work, for example, with tribes on what's called the Tribal Court Improvement Program, it's not for me to develop an affirmative vision for people who have suffered under the yoke of colonialism. That's a project for for those folks to create a future for themselves. And so that's why this metaphor I'm using of orientation or positioning is important to me, because I have to acknowledge and embrace like where my work ends, for example, and Sheldon's begins. That's an important part of how you do it at a broad level as a lawyer. So then lastly, I'll finish my comments here with how do you do it on that second inflection? Sort of how do you do it practically or as a praxis? What does it look like to be a Euro-Christian decolonial lawyer, if even such a thing could exist? This may be the last conference where I ever say those words together. Here's how I think it goes down. I think that the best I can do is work to create a space for decolonial praxis to happen and for indigeneity to express itself in whatever form it wants to take. So here's a few examples. I work on the Indian Child Welfare Act. I literally have spent time in my life, a significant part of my time, going to court and arguing that Indian kids should go home, that they should be connected back to their tribes. That feels like doing something. And I'm doing it within, I walk into a courtroom and it's a courtroom created by, it's a Western institution. I have, that's blatantly obvious to me. But the fight is about returning Indian children to their families, to their tribes, to their cultures. And that feels like something, that there's something decolonial, I think, about that. Another one is, as I mentioned earlier, the Capacity Building Center for Tribes. That's a group that the federal government funds, but that's led by a number of indigenous folks, and their job is to help tribes manage their own sort of child welfare issues. I hate to even use the word system. I think you know what if you're being, I think, charitable, you'll know what I mean when I say sort of like when child abuse emerges or happens in a tribe, then what? So the Center for Tribes is an example of potentially a space within this Western normative paradigm where there's an opportunity for indigenous folks to decide for themselves what they want to do with their kids and with their people. We also work together. There's two last examples. The Tribal Court Improvement Program is another program that Sheldon and I work on, and that program is designed to basically, it's just the federal government giving 7 different tribes a bunch of money and saying, do whatever you want to improve your tribal child welfare court system, including something as radical as building something that isn't a tribal child welfare court system. So there are those kinds of generative opportunities, like on the ground, in a practical way, or in a practical form. And then lastly, and this is, I'll just take a line from my own mentor's language, Dr. Tink Tinker. I think one of the biggest things that I can do in that second inflection is appreciate Indian difference. Resist the Western temptation to reduce things to the same. There's an interesting conversation going on right now with this acronym BIPOC that's floating around, which is Black, Indigenous, and People of Color. And a lot of the indigenous philosophers, thinkers, lawyers that I work with, and Black folks that I work with, find that kind of acronym problematic or troublesome because it's a conflationary move, right? The indigenous struggle is not the Black struggle. And so for me, a big part of the work that I do as an Indian Child Welfare Act lawyer is to appreciate Indian difference. And we can talk more about what that means, but it's not just saying, oh, I understand that you do things differently, but now let's work together. And by that, I mean, do it the way we're going to do it on the Fed side. What I mean is, at the deepest sort of philosophical level, recognizing the fact that when a Choctaw judge on the other side of the table says to me, we do it differently here, there's a deep for example, the dominant metaphor, operative metaphor for the Choctaw is
Andy,
yeah.
Andy, you just cut out there. You said there's a deep, and then you froze. Can you just?
Of course, yeah. Yeah, the difference that Justice Briscoe, for example, who's a Choctaw judge that I work with, when he says there's a difference between us, that difference runs deep. I mean, it runs to his bones. It runs to the ground. It runs through his grandmother and his tribe, and the depth of that difference is profound in a way that we on the Western side of things have got to appreciate and resist the temptation, not temptation even, but resist the desire to reduce things to the same. In other words, resist the desire to just listen till you say things that sound like what I already think. So appreciating Indian difference, we could say a lot more about that. I think is at the end of the day, probably the biggest thing that I can do as a Euro-Christian lawyer operating in the space that I'm operating in. I'll leave it at that. I want you all to know that I also have 10 ways to do it that I won't go down right now because I'm probably boring you. But if we wanted to get more into that kind of stuff, I do have some ideas on that. So I'll just wrap it up there. Thanks.
Great. And then Andy, there was a question that came into the chat, and but from Khan Simit, and if you want to read it out yourself, that's fine. But or if not, if someone could just vocalize the question, because the chat won't show up on a replay when we when somebody watches this later on in an archive sense. So we just want to be able to hear the questions.
Want me to read it?
Yeah, Khan says that they prefer not to read it if someone else could. So go ahead.
Andrew Yost, isn't your critique of neoliberal appropriation of identity politics applicable to everything that neoliberalism appropriates, and not a particular critique of identity politics? Is the square question. And then part two, identity politics needs to be placing the mirror up to whiteness and the invisible and default identities, which has always wielded the violence of identity.
Yeah, thanks, Sheldon. And thanks, Can, for the question. I really appreciate it. I would say a couple things about that. And again, you know, I'm not sure I'm right. Let me just be clear about that. I mean, I'm trying to engage in a thoughtful conversation with all of you. So I don't want to come off pretentiously like I have this all sorted out. So I'll just give you what my thinking is, and then I'm happy to hear some thoughts about it. Hopefully you can help me refine it or jettison it if it's bad thinking. But here's my basic thought. I do think that the ubiquity of neoliberalism allows us to make what you're saying, so what you're calling critique of the neoliberal appropriation of identity politics applicable to everything that neoliberalism appropriates. I think the short answer is yeah, I think you're right about that. Because for the most part, neoliberalism, and I'm using that term as sort of in the sense of like, you know, the globalized economy and the ideology that emerged out of that from the late 80s and so on. We could talk more about the refining our understanding of that phrase, but it does appropriate almost everything. But I still think that there's value in performing an analysis of the grammar and vocabulary of neoliberal ideology that's dominant. And when I say dominant, I mean literally on the headlines of our newspapers and in the mouths of our legislatures and our judges, for that matter. I think it's worthwhile to hone in our critique on those operative concepts and interrogate them. So for example, for me, there are a number of problems I think with identity politics as an emancipatory strategy, as a way of achieving liberation. One of them is that I think that, and again, I'm not arguing that there is no place for identity. I don't want to overstate my case. I do think that there is a place for recognition in identity politics, but I think that it has its limits as well, and it focuses heavily on recognition as opposed to, say, for example, redistribution of resources, for example. But for me, the more problematic part of my critique of identity politics, at least where I'm spending some time in my own thinking, goes back to the making of the Indebted Man. Now, Lazzarato's book is not about American identity politics. He's writing more in the European vein, and this is after the financial collapse in 2008 and the austerity movement in Greece and blah, blah, blah. But I'm trying to apply some of his categories and his analysis into the popular American discourse. And what I see is something like the language of debt operating as a corrective. And it takes the form of, for me, it takes the form of identity politics, where membership in a particular minority group creates a creditor-debtor, ideologically creates a creditor-debtor relationship, excuse me. But the irony of the debt is that it's ontological and can never be paid. And so there's a kind of, and this is the phenomenologist in me talking, there's a kind of phenomenological othering that happens that then gets latched onto the ideology of debt in a neoliberal register that I think becomes a mechanism for reinforcing oppression as opposed to serving a liberatory ends. I'll just leave it at that. Hopefully that was helpful.
I add one quick thing, actually, Roger, before I know.
Yeah, and then it looks like Luna has a question in the chat
Oh,
too.
yeah, I'll read that. Oh, Luna, unless Luna wants to read it. If not, I'll read it. Okay, I'll read it, Luna. If Black, Indigenous, people of color identity politics is conflation that reduces everything to the same, not recognizing difference, how do you recognize the difference of one who identifies as Indigenous with the African diaspora? Excuse me. Good question.
I want to just, Sheldon, I think that question's for me because I'm the one who brought up the BIPOC example, but do you want to say anything about it before I start yammering on?
Yeah, I'll say something really quick on it. So Vine Deloria, so one of the great academics of American Indians, and he wrote a few books that have really revolutionized Indian studies and Indian law as well. But he talks about this actually, and there is a big difference, I think, between here in America, the African-American experience and the Indigenous experience. There is some similarities, I'll add that though, because I live in Denver, and I live in a neighborhood where there's a lot of Black people. And I feel like I have more in common with Black people in my community than probably white people in my community here in Denver, Colorado. And so I think there are some similarities to where I'm oriented. But Vine makes this point, and I think it's a really powerful point, is that the history of relationships with disenfranchised people by colonial people has been this fight towards gaining rights. We want rights to vote, we want equity, we want equality. And so there has been a fight to do that. Where American Indians, the fight has been leave us alone. So the fight is we don't want to be a part of that. We don't want to be a part of the US system. The Indian Citizenship Act, 1924, happened not because of our pushing. We didn't want to become citizens. We were not citizens. And so we had our own sovereignty. And so there is that push-pull when we start talking about those identities and how that's framed our political participation and our current identity in 2021. And I feel like it's a smart place to start, actually, from Vine's perspective. That's what I wanted to add to that. So go ahead, Andy.
Yeah, thanks, Sheldon. And I'm 100% on. I would just continue on the line of thought that Sheldon just articulated. And here's what I would, here's how I would continue it. I don't have the answer, of course, Luna, and it's a wonderful question, and it's directly on point. I don't have the answer of how you recognize the difference of one who identifies as Indigenous within the African diaspora. I mean, that's just not, you can literally look at me and you can see that that's not a question that I can answer. So let me just acknowledge that first of all. What I would say is that, and I would just take a page from Walsh and Mignolo's work. In my opinion, which I find deeply compelling and has informed a lot of my work as a lawyer, what I would say is that decoloniality is not a theory. It's not a meta practice. There isn't a way of answering the question that will apply at all places and all times for people that are that are seeking recognition and are experiencing a resurgence or reconstituting themselves, delinking from the colonial matrix of power. There isn't one, and I find their critique of attempts to find them compelling. And I see things like liberal identity politics in the form of BIPOC acronyms as versions of that. What I think Mignolo is saying, and what I find compelling, is that the delinking and the reconstitution happens on the ground in local communities. You know, they use the Zapatista example a lot throughout their work, and I think it's a very good one. And it takes the shape of the folks who are doing the work and crafting the form of life that they want to engage in. And so what I find troubling about modern liberal American identity politics is it's so deeply unreflective. It, to me, is an ideological articulation of the underlying material conditions of the neoliberal capitalist order. And it doesn't attend to the radical particularity of histories and spaces and people and experiences that I think is part and parcel to the work of the Decolonial project. So hopefully, Luna, that's helpful, but that's at least my hack job at an answer.
And then we have a question from Douglas Laughlin, and Douglas has asked someone to read it. So I'll go ahead and read it out. Have ideas of pluriversity or legal pluralism informed your practices of law?
I'll answer. Definitely. So I've represented children and briefly for parents for 5 years. And definitely this idea of the overlapping systems that happen, especially in tribal courts, the overlapping of systems that happen where there's values that are borrowed from one to the other. Especially like I was talking about, I think maybe a good example, the way that I'm thinking about legal pluralism is in the Indian Child Welfare Act of there was a borrowing of values from indigenous societies. And this is a mechanism for, if anything, some justice, some sort of ability to leverage. And if lawyers are useful for anything, it's being able to leverage an argument within that to fight to get children. And it comes back to this idea of proximity. There's some power in proximity. All of us, when we become proximate to an idea or proximate to people, there's some power in that. And so being able to advocate for a child to become proximate to families, if that's not safe, proximate to culture, proximate to relatives. ICWA, the Indian Child Welfare Act, has been challenged. I do want to add this in here really quick. I got a private message in here about the Brackeen decision. So there was a decision that was just decided in the Fifth Circuit Court of Appeals. So this is one step under the U.S. Supreme Court. They actually impaneled all the judges in that Fifth Circuit, and these are the states of Texas, Louisiana, and Mississippi. And so this decision only applies in those jurisdictions. And they're really challenging the constitutionality of, if we take a step back, what's happening here is all these people that have no business, have never cared about Indian children ever, are now filing lawsuits of trying to undermine, and this is something to be aware of. And I appreciate Andy's critique. On the flip side of this, there's other people, and this is always something for us as tribal people, tribal lawyers to be aware of. There's other people trying to undermine sovereignty that we do have. Of course, it's a Western construct, but there's states, primarily I work for a tribal government. There's a lot of implications here, taxation, criminal enforcement. There's a lot of different things that are implied here. And then McGirt made that decision in Oklahoma, those that are followed federal Indian law. But Brackeen is challenged on 10th Amendment challenges, and it's also being challenged on the Commerce Clause of Congress's power to make a law that has to impact American Indians. Do they have the ability to do that without violating equal protections? And so that's fundamentally some of the questions that are being asked in that decision. There are some losses on that, and the losses that happened in that opinion, which the opinion is a mess, like I think it's 325 pages or something crazy like that. The losses actually happened around the Administrative Procedures Act, which is a federal act that limits executive regulations. And so the executive agencies can regulate, like if a law is passed, federal law is passed, they could implement regulations. And so in this case, ICWA was passed, and they had some regulations for the states to interpret it. And so how much power does the executive have of saying this is how you should look at this federal law that Congress passed, so how much power do they have? And so there was some losses on that as far as how the states should interpret it. But it's only limited to those areas. The bigger story in that is the challenging of tribal sovereignty. And so the last thing that I just wanted to say too really quick is, and I know we're coming close to time, is I think as a lawyer, you don't graduate law school knowing how to practice law. You don't do it. I did take a clinic, so I did know a little bit. My first job was with legal services. I didn't have a mentor. My first day of legal services, they gave me a file and they said, you have court over here. It's 2 hours from here. So here's your file. Good luck. So I'll tell you, when I was, I'll admit this, you wouldn't want me as your lawyer when I first started. I didn't know what the hell I was doing. I was very insecure about the procedure. I was very insecure about what was going on. I was really worried about losing on my client's behalf. Parents, we did protective orders, so I was very nervous about that. But I ended up learning that I had other skills, actually, and a lot of my skills actually had to do with out-of-court representation. And one day I learned this, and I'll tell this really quick, and this is the answer of this pluralism of how it's informed my practice as a lawyer. It made me, in my mind, a better lawyer, because I ended up learning the tricks. I learned how to file motions. I learned how to win those motions. I learned how to flip the table on a cross-examination on a witness. I've learned those tricks. They're not hard to learn. You probably could learn them by watching a YouTube video, honestly. They're not really that hard to learn. Having humanity in the practice of law is hard to learn. It is really hard to learn. But I had this mistaken idea that if I worked harder as a lawyer, I'd get better results. It flipped for me when an elder of the Ute tribe, I was in tribal court, he came and talked to me, and he told me, you know what this is all about? It's about proximity. It's about getting closer to values of tribal culture. And it reminded me of that, actually, and it made me a better lawyer, a better advocate, of being able to argue that the best interest of children is being proximate to culture, being proximate to family. Forever, the rest of my life, I feel like I'm still young, but I'm probably, I just turned 40, so I'm getting up there, but I feel young. But I think for the rest of my career, that however long I do this, the thing that I'll be the most proud of is on the ground, in a tribal community, we were able to reduce the amount of kids in foster care by half, and able to flip where 20% of the kids that were in care were placed in relative care. So it's a very small number. And we were able to increase that up to 80%. And that was a team effort that happened under. And I feel like some revolutions can happen. Humanity can happen when it comes to this area of law, that other areas, it cannot happen. The challenge that I would also add, and I'll end here and hear what Andy has to say, and it's something for us to think about, I think, is that the work that Andy and I do, and I've challenged Andy on this a couple of times, with tribal court improvement, most of the people that work at tribal courts do not have tribal values. They're actually oftentimes non-Indians that are driving into the community and representing families, representing children, or being the judge or the director of social services. And so sometimes that federal engagement, actually even with the wrong people with the wrong values, actually, or have Western values to begin with. So to begin that conversation of, let's do it the Northern Cheyenne way, sometimes you're not, or let's do it whatever your tribe is, let's do it that way. Sometimes you're also talking to a non-Indian in that discussion. And so if it's the guy that runs that federal program who's also a non-Indian, and maybe the consultant they're providing is a non-Indian, it's three non-Indians having a conversation of how to take care of Indians, Indian children. And so that is something for us to be mindful of and thoughtful of. Sometimes we have the wrong people in the room. I was fortunate when I represented children to have this Ute elder to come and pull me aside and give me a lesson, because I'm not Ute, I'm Cheyenne, and he was able to say, hey, you need to pay attention to this. And I guess I was fortunate enough and tired enough and weary enough that I was humble enough to listen to what he had to say. I could have ignored that. So that's kind of my answer about that. The long drawn out answer to that question about the intersection of Western and customary law when it comes to this area of practice.
Thanks, Sheldon. There's one more question in the chat from Luna, and then we've got about 5 minutes left before the next session has to start. So I'll let you guys, Andy or Sheldon, answer the question or read it out from Luna. Thanks.
Sure. Sheldon, you've done a lot of reading, so I'll go ahead and read it if that's all right. So it says, perhaps the decolonial project will benefit from a global marginalized identifier, particularly in international human rights law. I'll admit, I'm not sure I understand the question. It's probably almost certainly actually from my own ignorance. So Luna, can you maybe just type into the chat, or if you want to speak over the line, it's fine too. Just tell me a little bit more about what you mean.
Yeah, I was just, thank you, just thinking about signifiers, right? The signified. And I'm going back to the BIPOC issue. And I read an article by a woman of color, an academic, and she was saying, you know, I'm tired. She's in alignment with you about this BIPOC, neoliberal identity politic that's being circulated here from a US-centric perspective. And she says, I think it's a more liberative practice if we identify as the globally marginalized, because those that are indigenous, those that are Black, et cetera, people of color that represent the majority on the planet are actually minoritized and the greatest marginalized.
Yeah, I mean, it's an interesting concept. I won't go too deeply since we only have 3 minutes about the second. I won't say much about the second part of your question about human rights law, but that's an interesting. I clerked at Harvard's program on humanitarian policy and conflict research when I was in law school, and there's a lot to be said about that body of law and the limits. I think, in my opinion, the limits of it and the decolonial project. But I'll just say, and this is maybe a different version of what I've already said, so I apologize if it sounds a little redundant, Luna, but for me, the big part of the project as a lawyer engaging in decolonial praxis is essentially getting out of the way and letting folks speak for themselves, and then committing what resources I have to supporting their reconstitution in a supporting their reconstitution. So how we frame the question of the global marginalized, or the locally marginalized, or the modern narrative of marginalization and the geography of it. I mean, that I'm clearly interested in that as a topic because I'm here. But I'm also reluctant to, I'm reluctant to engage in what I kind of consider like this conceptual overreach without having thought through what categories we think are the best to apply in this arena with the people that they directly affect, which is why, like, I've never said this to you, Sheldon, but why shouldn't I just say it with 1 minute left in a public forum of 100 people? That's why I love Sheldon and why I love working with him. It's because there's a deep, like, to use his word, humanity when I sit face to face with him and do the work together, that I think for me, I start to get a little nervous about, you know, global marginalized, those kinds of categories, because I feel like something is maybe lost there. But I also would want to hopefully think that through a little more, Luna, so I apologize if that was not as wise or intelligent as you'd hoped it to be.
All right. Thank
I'll
you.
add really quick to that. I'll add probably 2 seconds. Actually, Walter Equihawk, he's a Pawnee lawyer, and he wrote a book called In the Light of Justice. And it's kind of interesting. He makes this argument that international law for federal Indian law, it is the pathway to save federal Indian law, you know, to bring humanity to federal Indian law. So, and he's very specifically looking at the UN Declaration of the Rights of Indigenous Peoples as a lever, human rights as a lever to effectuate harmony within tribal communities. And it's kind of ironic. I find it ironic because, of course, the doctrine of discovery comes from international law. And so on the other bookend, we have UNDRIP, which is international law, and as the pathway out, and that might be the case. And so, but I just find some interesting poetic irony in the whole thing. So, good question.